Welcome back to I Couldn't Help But Wonder, Divorce Decoded, where we untangle the legal, emotional, and financial threads of modern divorce one story at a time. I'm Lorraine Silverman, and today we're exploring one of the most misunderstood and most debated parts of divorce, alimony, or as we call it in New York, spousal maintenance. Episode 3, The Alimony Anomaly. Some relationships end with a dramatic exit, a suitcase, a slammed door, maybe even a well-timed playlist. But others end with something less poetic, a payment schedule. I couldn't help but wonder, when a marriage ends and one partner still has to financially support the other, is that love, guilt, or just alimony? In a world where power couples become court cases, how do we make sense of spousal maintenance? The story, the consultant and the composer. Chloe was a management consultant in Albany. Long hours, high stress, first-class flights. Eli was a composer, gifted but still waiting for his big break, content to write in their sunroom with the baby monitor buzzing nearby. For a while, it worked. She supported them both financially and otherwise, but when the marriage dissolved, the balance sheet became the battleground. Chloe didn't mind supporting Eli when they were together, but did she still have to after the divorce? As she signed the 7th draft of her statement of net worth, she couldn't help but think, I'm paying him to leave me? Legal breakdown. How spousal maintenance works. In New York, what we commonly call alimony is actually referred to as spousal maintenance. There are 2 types. Temporary spousal maintenance, which is awarded while the case is pending, and post-divorce spousal maintenance, which is awarded after the divorce decree is issued until a terminating event, such as the death of the party paying spousal maintenance, the remarriage of the party receiving spousal maintenance, and such other factors ordered by the court or agreed to by the parties. Like child support, there's a formula for calculating spousal maintenance based on the incomes of both parties. This formula is set forth in Domestic Relations Law Section 236B 5-A. However, the court can deviate from the formula to take into consideration certain factors when appropriate. These factors are the age and health of the parties, the present or future earning capacity of the parties, including a history of limited participation in the workforce, the need of one party to incur education or training expenses, the termination of a child support award before the termination of the spousal maintenance award when the calculation of maintenance was based upon child support being awarded. The wasteful dissipation of marital property, including transfers made in contemplation of a divorce action without fair consideration. The existence and duration of a premarital joint household or a pre-divorce separate household. Acts by one party against another that have inhibited or continue to inhibit a party's earning capacity or ability to obtain meaningful employment. Such acts include, but are not limited to, acts of domestic violence. The availability and cost of medical insurance for the parties. The care of children or stepchildren, disabled adult children or stepchildren, elderly parents or in-laws provided during the marriage that inhibits a party's earning capacity. The tax consequences to each party, the standard of living of the parties established during the marriage, the reduced or lost earning capacity of the payee as a result of having foregone or delayed education, training, employment, or career opportunities during the marriage, and any other factor which the court shall expressly find to be just and proper. And when looking at post-judgment spousal maintenance awards, the same factors are applicable as in temporary awards, but the court can also consider the following factors: the equitable distribution of marital property and the income or imputed income based on the assets so distributed, the contribution and services of the payee as a spouse, parent, wage earner, and homemaker to the career or career potential of the other party, and the anticipated retirement assets, benefits, and retirement eligibility age of both parties. And in addition to the amount of spousal maintenance, the law provides an advisory schedule for the length of time, called duration, that spousal maintenance should be paid. This is keyed to the length of your marriage. For example, a marriage lasting 15 to 20 years would presumptively result in a spousal maintenance payment for 30% to 40% of the length of the party's marriage. So, in Chloe and Eli's case, Chloe earned significantly more, and Eli had been out of the traditional workforce for years. The court would likely award some maintenance, at least for a period, to help Eli transition. But here's the key. Spousal maintenance is rarely forever. The longer the marriage, the longer the term, but courts expect that both parties will eventually become self-supporting where possible. This can also be manageable and fair with a good lawyer and a creative divorce proposal. The takeaway? Spousal maintenance isn't about punishing success. It's about fairness. Whether you're the higher earner or the partner who paused a career for family, the most important thing is telling your story clearly, your needs, your contributions, and your future. Because when it comes to spousal maintenance, it's less about what's fair in love and more about what's fair under the law. Thanks for joining me for what I couldn't help but wonder Divorce Decoded. Next week, we're diving into custody. Who gets the kids, the calendar, and the carpool? In the meantime, if you're wondering whether you'll owe or receive spousal support, visit thecdslawfirm.com to schedule a confidential consultation, because love may be unpredictable, but your financial future doesn't have to be.